Detectives arrested 28-year-old Bryan Christopher Kohberger on a warrant for murders of Ethan, Zana, Madison, and Kaylee.
He was stalking them. He was hunting them.
You could tell there was something off about him.
A quadruple homicide in Moscow, Idaho, it's just unheard of.
This is our home. This is our university. This is our community.
These murders have shaken our community, and no arrest will ever bring back these young students.
This was a violation of everything.
Let's talk about the Idaho student murders case now. It's what's trending in true crime. Bryan Kohberger is the man charged with those fatal stabbings, and he was back in court on Wednesday. Both sides arguing what's called those motions in limine, the motions ahead of the trial. They really set the stage for everything, and that trial marker calendar is set to begin on August 11th. There were over 20 different motions taken up by the court. We want to talk about some of the key motions, so we've pulled them out here. One of them coming up has to do with Bryan Kohberger's autism diagnosis, and if he is convicted, whether or not it could be used as a mitigating factor as to whether he should receive capital punishment. Let's talk about the killer's bushy eyebrows. We know that one of the surviving housemates said she saw the man wearing dark clothing, athletic build, wearing that dark mask, but saw the bushy eyebrows. Well, the defense doesn't want that coming in. The judge took the arguments under advisement. We'll see what he rules later. But we want to talk about that because we know that's really key in this description, right? We know that this surviving housemate didn't make a direct identification of Bryan Kohberger. He's just the accused. So is it likely the judge is going to exclude her descriptor of the bushy eyebrows? Let's bring in attorney Dave Ehrenberg now. Dave, you're the perfect person to help me unpack all these things. So starting with that, the bushy eyebrows issue. Do you see this getting excluded?
It shouldn't, Julie, because it's relevant evidence. You have an eyewitness there, a surviving roommate, who said, I saw this individual wearing a mask, but these noticeably bushy eyebrows. And you could see in pictures taken of Kohberger right after a selfie he took right after the murders, a really creepy one, that he has bushy eyebrows. And it is noticeable that when he sits at the defendant's stand all made up, that those eyebrows have been trimmed. Let the jury decide whether that is evidence of his guilt. But to exclude it altogether, I think would be a mistake.
Excellent analysis, Dave. Thank you for that. I want to turn to something else here, and you know well the law on capital punishment, what it involves, having to make the weighty decision to seek such a punishment on a homicide case, having served as the state attorney in Palm Beach County, Florida. In this case, we know the state of Idaho is seeking the death penalty against him, and his defense team wants to use his autism as a mitigating factor. Do you see that being permissible?
One of the advantages, Julie, that defendants have is that you can list any mitigating factors. See, prosecutors have a list on the statute that says, here are the aggravators, and they have to prove at least one aggravator beyond a reasonable doubt. But when it comes to mitigators, the defense can choose anything. You remember that horrific murder at Parkland, not far from here, this Marjorie Stoneman Douglas massacre. The reason why the young man there escaped the death penalty was because they said, well, his mother smoked while he was in the womb. So you can come up with any crazy reason to try to get one or more jurors to say, yeah, let's not give him the death penalty. So they can try the autism, but the defense is saying it should be taken off the table. The autism should take the death penalty off the table entirely. It shouldn't even go to a jury. And of course, I strongly disagree with that. Having autism or even a slight autism, it's questionable whether he has autism at all, quite frankly. I mean, he's a doctoral student who acted pretty normally when the cop pulled him and his father over on that long drive back to Pennsylvania. But even if he does have some level of autism, that alone is not enough to take the death penalty off the jury, away from the off the table and away from the jury. They should be able to decide.
Yes, Dave, I love it. Preach. I've got another issue I want to pick your brain on. That has to do with the 911 call placed by those housemates. We know this was made hours after the homicides were committed. Let's take a listen to some of it now.
911 location of your emergency.
Something is happening. Something's happened in our house.
you don't know what.
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night and she not wake me up.
Okay.
Oh, and they saw some man in their house last night.
Okay, I need someone to stop passing the phone around because I've talked to 4 different people.
Okay, sorry, they just gave me the phone.
Is she breathing?
Hello?
Is she breathing?
No.
Okay, so the defense team wants to keep the 911 call out. The judge is going to give some guidance at a later date on whether it will be admitted, and the judge hinted at some possible redactions with its admittance, so we'll wait for that. And then there's the other issue of the Amazon click history for Bryan Kohberger. The defense wants to have excluded some purchases that he made. The state is pointing to deliberate actions that indicate premeditation because he bought a K-bar knife and a sheath to go along with it months prior to the homicides. And the judge will allow that Amazon evidence to come into the trial potentially. I don't believe there's been a ruling on that. Someone correct me if I'm wrong on that. I think it's still up in the air. Okay, so Dave, let's take these one by one. The 911 call. The defense, I don't know what they want in. I think they want a trial without any evidence at all because, like, they just don't want to know. No talk about bushy eyebrows, no 911 call. The call's pretty harmless if you ask me. They're not saying it was Kohberger in the house or anything like that. That's, they're just, there was a man in the house. We don't know that it's Kohberger. What do you think? Do you think that it should all come in? Do you think it should come in with redactions? Give us your take, please.
I guess the defense argument is, Your Honor, this evidence is too harmful to our client. Well, yeah. Too bad. Tough luck.
You should be a judge, Dave. Please be a judge next in your career.
I'd love to wear the black robe and have everyone stand up when I enter the room. It's a great gig to be a judge. Yes. Right? Julie, you and I feel the same way about this. It's like, come on. This is real evidence. This is a present sense impression. This is what the individuals there saw and felt at that time. It really shows the chaos, and it's real life. And also, it debunks the whole myth that somehow the roommates were in on it, that somehow they were the killers themselves, or that they somehow were complicit. No, these people were just discombobulated. They were hungover. They'd been drunk the night before. They were freaking out, passing the phone around, having a neighbor come and help them because they could barely speak. And yes, that fact that they said that the roommate was passed out, I think that's what a lot of people would do rather than to admit that our roommate is dead. Who would ever want to say that? You say she's passed out. You don't want to ever believe that she was murdered. And so that's coming in. And then as far as the Amazon purchase, come on. You don't think it's relevant evidence that the defendant purchased the same type of knife and sheath that was used in the crime and then afterwards went back to try to buy another one? I think it's very damning evidence, and it will come in.
Yes. Ding, ding, ding. You were right, Dave. I just got confirmation from our control room. Katie, thank you for this. Yes, the judge did make a ruling on that. There were so many motions the other day. It was hard to keep track. But yes, the judge says it can come in. So to your point, Dave, you were right. How vital is it to the state's case? Dave, what do you think? The fact that he buys this K-bar knife, exact same knife used, buys the sheath left behind with his DNA on it, yikes.
It's very powerful evidence, but they've got so much other powerful evidence that even if this didn't come in, I think he'd still be found guilty. The number one best evidence is his own DNA. He can't get around that. He's not going to be able to say that someone planted his DNA there. His goose is cooked.
Sure is. Dave Ehrenberg, you're the best. Thank you so much for taking time to come on the program this morning. We've missed you. Come back again soon, please.
Thanks so much, Julie.
Oh, sure.